What I'm going to talk about here is the impact of this device, which is a smartphone, on jurors. All right, I've written several pieces on that, and we're going to talk a little bit about that. Just not smartphones, but mostly people come to think of smartphones, but just really what the internet is doing to jury service. All right. So, title of my presentation is Google Gadgets and Guilt, Juror Misconduct in the Digital Age. So I'm going to talk about some of the negative components of what is happening in the court system with respect to when jurors come in contact with the internet. All right, let's start off with some examples. Okay, and if you want, when I teach my courses, many of my students use laptops. I encourage folks to use laptops. And if you want, if time permits, I will jump on the internet and we'll do a search of Twitter. And if you want to now, you can go on Twitter, do hashtag jury duty, and see what people are saying. See what those folks are saying about their service. Some people are bemoaning that they have to go to jury duty, but others are actually talking about what's going on in the courtroom. And here's some examples. Guilty, he's guilty, I can tell, jurors, it's a juror's tweet. In my honest opinion, defendant guilty, jury duty, complete waste of time. Whoa, I wasn't expecting to be in a jury deciding a pedophile's fate. I've always wanted to blank a pedophile, now I'm within the law. All right. Federal trial in Florida, 9 of 12 jurors had conducted online research. And here's actual jurors' Facebook post. All right. Actually excited for jury tomorrow. It's going to be fun to tell the defendant they're guilty. All right. I'll just pick one of these. Look at that Facebook post there. This juror wrote that after 1 day of a 2-day trial. All right. This person had already had their mind made up, okay, and the defense had not even presented any evidence. And if you were savvy, if you were on the ball, and you were monitoring these jurors like I will talk about, you would have discovered this information. And that might, well, not might, it would impact how you're going to handle this case. All right? So these are, I want to give examples of some of the problems that the court system is facing right now. I'm going to talk about them. Juror communications and juror research. All right? Now some of you may say, well, that's not a problem. All right? I don't see any issues here, so let me get into a little further detail of why it becomes problematic when jurors conduct their own research. All right. Exposes jurors to outside information. All right. So the way our legal system is set up, we have an adversarial system. Okay. We have two parties going at each other to effectively determine what the truth is. All right. And the judge serves as sort of a gatekeeper in deciding what information the parties are going to be allowed to talk about and present to jurors. All right. But this process, the internet, smartphones, allows jurors to circumvent the adversarial system. They can, on their own, find out certain information. Okay? The problem with that, though, is many times the information they find is inaccurate. All right? Here's an example here from a Rhode Island juror. Rhode Island juror researches definitions of manslaughter, murder, and self-defense. But unfortunately, he's using definitions derived from California statutes. All right? These are terms of art. All right? They have different legal definitions depending on the jurisdiction. But even besides inaccurate information, the attorneys don't have the opportunity to cross-examine this information. All right? They don't have the opportunity to put this information to the test because it's never presented in court. All right? So there's numerous examples of jurors going online and looking up terms like probable cause, rigor mortis, reasonable doubt. These are all things that jurors want to know to help make their decisions. Okay, so now, why? Why are jurors going online and conducting their own research? Well, let's take a step back and look at the reasons. All right? This is not a new concept, though it's become more common. But we've all, throughout this country's history, have had jurors violate the court's rules. And so why are they doing that? Well, you have a couple of reasons there. Call them the 3 C's. All right. Curiosity. Jurors are on jury duty. They want to know why certain things are kept out. They see an attorney make an objection. The objection is sustained. That information or that question will not be asked. Well, jurors, like most human beings, they want to know why. Why was that information disallowed? Okay? Because they're the ones who have to make the ultimate decision, so they want to know that information. All right? So there's this curiosity. All right? Then there's confusion. Some attorneys don't do a good job of explaining the information in a way that the average layperson can understand. All right? So they're confused. All right? This confusion is exacerbated by the fact that they can't talk to anyone about the information they just received. All right? They can only communicate with other jurors during the deliberations. And that could be days, sometimes weeks, even months later. All right? So they're confused. And in some cases, the stakes are very high. You could be sitting on a capital case. All right? Then there's the conscientiousness. All right? For the most part, I believe, jurors want to do the right thing. They want to make the right decision, but they feel they don't have all the information. They feel they can make a better decision if they know more. I'll give you an example of some conscientious jurors who did the wrong thing. All right, there was a high-profile murder trial here in Southwest Ohio involving a man, Ryan Widmer. All right, he was convicted of drowning his wife in the bathtub. All right, now Mr. Widmer's legal defense was, I came upon my wife in the bathtub and she was passed out. I pulled her out of the water, called 911, pulled her out of the water, put her on the carpet in a room, and I started listening to 911. I started applying CPR to try to resuscitate her. The government said, no, that's not what you did, Mr. Widmer. What you did was you killed your wife, set the scene, set the stage, then called 911, and they came. So you had these two conflicting theories. And the EMTs, when they arrived, they testified and said, we got there, and we were going to try to shock her heart, get her heart going again. And in order to do that, we needed to find a dry portion of her body. And it wasn't hard because her body was dry. All right? But hair was wet, body was dry. So a big issue in this case was, how long does it take a human body to dry? And apparently, at least for those folks, there's no expert in this country who does that, all right? Who determines how long it takes for a body to dry that's wet, okay? So there was not testimony to say, okay, this is how long it takes a human body, the average weight, things of that nature. So the jurors were concerned about that because it mattered, because how fast did the EMTs, if you bought his story, all right, then it worked. But depending on how long it took for that body to dry, then his theory could work. So it was very important to see how long it took a human body. So what did the jurors do? They decided, well, you know what? Let's do our own experiments. All right? So 3 jurors went home, took a shower, stood outside the shower, and timed themselves. All right? These aren't bad people. They just want to make the right decision. The stakes are high. All right? Mr. Widmer serving 15 to life. Stakes are very high. All right? So they want to do the right thing. Okay, so those are the traditional reasons why you had folks doing research. Okay, so now let's fast forward to the digital age. All right, so we have those reasons. Then let's compound the reasons now with the internet. Okay, popularity of the internet. We heard the last speaker. All right, talked about how common it has become for people to use the internet. We all know that already. All right, but it's easy to do. If there was an accident someplace and you weren't familiar with that, you might not drive over there to see what the accident scene looks like. All right? You might not want to do that. It's far away, out of your daily commute. But you don't need to do that now. Not with Google Earth. You don't even have to leave your office. You can go and see the accident scene. You can see what the street looks like. All right? It's much easier to do this type of research. Okay? Much easier to do that. And the amount of information. There's tons of information available. All right? Even on the most mundane cases, there's people out there blogging about them, talking about them, all right? And unlike, say, a high-profile trial where you may, or if something that's no longer in the news cycle, you don't have to go to the archives, to the library. No, much of that information is still on the internet somewhere. You just have to go digging for it. Oh, and then another reason is the jury instructions have not kept pace. All right. So we have a case there. It's a case from South Dakota Supreme Court. All right, it says, let's see if we can, it says it. So a juror receives a summons. All right, on the summons it says, you have been selected to serve as a juror on a trial involving, and they give you the name of the case, Russo v. Takata et al. And Takata is actually a corporation. And then they tell you on the summons, it says, do not seek out evidence regarding this case and do not discuss this case or the questionnaire, blanked out, but it said, with anyone. All right, so that's the instructions this individual got. So he said he did what like some of you may do. You know, if you are going to meet somebody for the first time, all right, or you just met somebody for the first time and you want to know more about them, all right, you're applying for a job, you want to know more about that job or the people you're going to interview with, all right, what do? You Google them, all right? If you haven't already, Google yourself. See what comes back. See what type of information is listed out there on the internet about you. Well, that's what this juror did. He Googled Takata, all right? Because he doesn't feel that's seeking evidence. He said that's what people do. You Google somebody when you want to know something, all right? So he Googled Takata. He found out Takata was what? They manufactured seatbelts. And then the third hit, it said that Takata was not involved in any litigation, all right? So this juror makes it all the way through the process, and this person is selected. So 15 minutes into deliberation, this is a wrongful death. They're arguing about whether or not this, the Takata actually, the seatbelt properly functioned because someone died in a car accident. So these plaintiffs are bringing action against Takata, sue them for the wrongful death. What's the first thing out of this juror's mouth once he's in deliberations? Oh, I know Takata. They're good guys. They've never been sued before. All right? Okay. Well, that's a mistrial. You can't have that type of information. And so maybe if the instructions were worded differently, then maybe you would not run across that kind of problem. But that's an example. All right, now we're on juror communications. All right, jurors communicating with each other. Historically, not a problem. All right, jurors want to talk with each other, usually not a problem. Most jurisdictions, you can't talk about the evidence until all the evidence is submitted. So you just sit there and just stare at each other and talk about baseball or the weather or something, but not about the evidence until all the evidence is submitted. It's not all jurisdictions, but most jurisdictions are like that. Now, if you violated that rule, not a big deal for the most part. They're not going to overturn the case because you're going to talk about the deliberations anyways. You're going to talk about the evidence eventually anyway. So they're unlikely to overturn the case because of that. The problem now, though, is how are folks communicating? How do they communicate now? Are they at the water cooler? Are they when they're passing in the hallway? The problem now is jurors are using social media to communicate. All right? Now that opens it up for others, outside parties, to get privy to this information. And then that's where the problems arise. All right? That's where the problems arise. All right? Because communications done through social media, depending on your privacy settings, can be discovered by others. Okay, like I said, not a big deal. So here's an example, one of the more egregious examples. So this juror in England has a jury system based on the common law. That's where we derive most of our legal system from. A juror was on a sexual assault case in England, all right? And she apparently was having difficulties deciding whether the person is guilty or innocent. All right? So she held a what? A Facebook poll. All right? Ask her friends, I don't know which way to go, so I'm holding a poll. All right? Improper influence. Okay, so what are some of the reasons for juror communications? To understand possible solutions, we got to look at some of the reasons. What are some of the reasons why jurors violate the court rules? All right. Similar, in many ways, reasons given for research. All right. Some folks are unaware of the restrictions. All right. They're unaware of the restrictions. They're told don't communicate about the case, or don't discuss the case, but to them, tweeting, blogging, an update is not necessarily a discussion to them. All right. A discussion to them may be a one-on-one conversation that we have. But I'm just tweeting. I'm just talking to the world. All right. I'm just blogging. All right? But you happen to be writing about the case, but you cannot. All right? Then there's this addiction. I'm glad I saw the last speaker who talked about that. You know, are folks addicted to the internet? Are they addicted to social media? All right? They can't go 8 hours, much less a week or a month without telling people or talking about their daily activities. All right? They can't put it down. All right? Then what my wife likes to call the tell-all generation. Is there a generation of folks being raised who must tell the world everything they do every 15 minutes? I got out of my chair, I put on my coat, I walked over to the STAR Symposium, I grabbed a coffee. See, there's some people who feel the need to do that. Now, if you fall into that category, it will be challenging for you to be on jury duty because you want to tell the world what's going on every 15 minutes, if not sooner. All right? So those are those concerns. All right. So what's some possible solutions? So I have 4 solutions up there. All right. Penalties, investigations, questions, improved jury instructions. All right. Let's look at some penalties. All right. I think penalties should be a last resort, in my opinion. Now, the last resort because we need jurors to serve. All right. They're not there for the money. All right. They get paid hardly anything. All right. It takes up a lot of their time. They got to worry about childcare, things of that nature. How are they going to get to the courthouse? So if you really want to get a jury duty, it's not that hard. And if you start penalizing people, I think you may have an increased number of folks who decide, I don't want to play. All right. So different forms of penalties. We have contempt. You can hold a juror in contempt for violating the court's rules. You can, you can fine the juror. You can make them, I've seen them make them write essays. You can tell them they're going to pay the costs for everyone coming down today since we had to have a mistrial. Different things you can do with respect to contempt. Then there's the Luddite solution. Give me your devices. All right? When you come in here, we're going to take everyone's device. Well, that would work if all the trials were done in one day, but for the most part, they're not. All right? So what are you going to do once those folks go home? Are you going to monitor them to that extent? So that's the challenge, I think, there. Now, they still do that with respect to deliberations. If you go in deliberations, they will take your phone because the room is pretty sanitized. There's really nothing in there. There's no books. They don't even place the Bible in the jury room. So I can see for deliberations, but on a daily basis, then you also create sort of a logistical problem in that you're responsible for those people's communications. All right, so it's difficult. Then there's sequestration. All right, not talking the federal government sequestration. I'm talking about putting jurors up in hotels. Nobody really has the money for that nowadays, or they only do that for the generally capital crimes. But there's this concept of virtual sequestration. All right, so you give jurors, you friend the court. All right, you become their Facebook friend. You allow them to monitor your devices. Now, that is, more an academic theory than actual application. But there's a version that does happen with respect to that, in that they now do investigations. All right, attorneys are increasingly investigating jurors online. Okay, that's what people do. They will check you out. They will monitor your social media activity to see if you say anything about the trial. They do that for a variety of reasons. One, to discover misconduct. Another reason, because they want to appeal to your interests. And if they know you're a big enviro person, they may make a reference or metaphor to some environmental issue. All right? Because they want you to like them, because you're the decision maker. All right? And they want to please the decision maker. So they investigate jurors for a variety of reasons. The concern here is that jurors, you're not going to catch all the misconduct. And depending on someone's privacy settings, you may not see what they do. Penultimate suggestion here are juror questions. All right? Allow jurors to ask questions. All right? Several jurisdictions allow that. Now, the reason I think this is a good suggestion is because it goes to the root of some of the problems of why jurors violate the rules. All right? Because they're confused and they're curious. This reduces that because you're now allowing them to get the questions answered in the courtroom as opposed to going on the internet or asking their friends. All right? So now, granted, you can't answer all questions, but this is a good opportunity to re-educate jurors on why all information is not good information. All right? And to give them the same respect that they would want if they were sitting in defendant's chair. Okay, final suggestion is jury instructions. This is one that most people recommend and suggest. It's very popular. Change the way the instructions are given to jurors. All right? Use more straightforward language. All right? Things that are easily understood by laypersons and not created for attorneys. All right? But I think the most important part of the instructions, you have to provide the jurors the why. Folks who really believe in Google we trust, They have more faith in Google than what they hear from oral testimony. If you want to break that chain, you got to tell people why they must give up their reliance on the internet and listen to the evidence that's submitted. All right? So the why in the instructions is very important. Because today, historically, just tell the jurors they're going to do it. Well, they're less likely to do it now because it's much easier to violate the rules. All right? Much easier. You would add a self-policing section where jurors would have to rat each other out. This is good because if one juror violates the rule, that juror is less likely to spoil the other or ruin it for the, or infect the other jurors with this misinformation. So if there's a self-policing section, a juror may hold on to any information they received improperly. There's procedural issues talking about the process of giving the information. How often should it be given, these instructions, whether or not you should have jurors actually swear and affirm the instructions. When a person is brought to jury duty, they take an oath, but do you want to have them actually write on a piece of paper, say, I swear that I will follow the judge's rules with respect to these specific instructions? That enhances, puts them more on notice of what these rules are and the repercussions. You also want to talk to them about some of the negative consequences. All right? What can happen if you violate these rules? These people have been down here, 2-3 week trial. They've got to do it all over again. All right? We've got to pay for all this all over again. All right? It's a big time and effort. And now, because you were so curious, all right, now we have to do this all over again because some juror could not follow the rules. So tell them some of the negative consequences and the fact that you can be held in contempt, you can be fined, you can actually be jailed. In this country, we don't jail. It's not that often that it happens. It has to be very flagrant a rule violation. However, in England, they're much more likely to incarcerate people for violating their rules. We're not there yet, but I see judges in this country taking a much tougher stance.